To summarize the proceedings of the case, we shall start with the respondent's strength, which is the MK party, and then we shall also discuss the applicant's challenges, which are the expelled 10 MK party members. The strength of the respondent's arguments. The respondent's counsel raised significant issues regarding the jurisdiction of the court, the urgency of the application, and the lack of procedural correctness by the applicants. The court seemed particularly concerned about the absence of MK party's constitution, which is a crucial document for determining the legality of the actions being contested. However, the respondent effectively argued that the applicants might not have a valid legal basis to seek the relief they were asking for, given the issues around their membership and the timing of the application. The respondent's counsel highlighted the procedural errors and the lack of supporting documentation from the applicants. The applicant's counsel faced difficulties with the late filing of confirmatory affidavits and the overall management of the case, which the judge highlighted as problematic. The judge expressed concern over the lack of sufficient evidence and procedural issues, such as the missing of MK party's constitution. The applicant's argument hinges on the interpretation of administrative justice and whether the actions taken by the party leader Jacob Zuma were lawful or not. However, without the constitution, their argument may lack the necessary foundation. This challenge was also apparent during the court proceedings, where the judge questioned the adequacy of the evidence presented by the applicant. The respondent appears to have the upper hand based on the concerns raised by the judge and the procedural weaknesses in the applicant's case. The applicant's case, while potentially strong on its merits, is undermined by the procedural issues and the lack of critical evidence, which the court will likely consider heavily in its decision-making process.
The High Court has found that the applicants have failed to show a prima facie right worthy of their protection. It also says the applicants have not established a reasonable apprehension of irreparable harm if the interdict is not granted pending the review application tentatively set for next month. The 10 MK MPs also wanted their benefits to be restored pending the finalization of their review application. They claimed they were paid 12,000 rand instead of 102,000 in mid-August after they were dismissed. However, the court has ruled that the applicants have shown no evidence that they will suffer irreparable harm. Parliament had undertaken to abide by the court's decision, but legal advice pointed out that only an interdict can stop the swearing-in process. The new MK party MPs were sworn in about a week ago. In defense of the party, MK party leader Jacob Zuma said in his affidavit that the party's interim leadership corps, ILC, resolved that the party president Jacob Zuma has the sole discretion on the deployment until the elective conference, including the power to remove any person from any structure after consultation with the ILC. Zuma says 90% of the 800 names submitted to the IEC by the former acting Secretary General Thandupolo Jodo were unknown to him, hence the cleaning up process led to the expulsion of the members. Ulelani Philip, SABC News, Cape Town.
I would say even without the court dismissing the urgency of the interdict, of course, pending the review application, you had already gone ahead, I suppose, firstly removing the MPs, and you say you spent money changing locks, you have put in replacements, you have already cut their salaries. They say they only got 12,000 that other month. So you had gone ahead even before this court ruling.
It's disingenuous of them to have made such remarks in the beginning. They put the cart before the horse. They misled the public by, firstly, even in that press briefing. We would do nothing of that nature. Look, in good nature, we allowed them, them knowing very well that it was going to be for a temporary measure, to occupy the role of members of parliament. So why would we be, at the last minute, be punitive? We're not. These are just, like we say, recalcitrant, members who are ill-disciplined and who should have just engaged with the party leadership. And this is something that could have been resolved where they are either deployed elsewhere. It's not something that they didn't know. And I've mentioned also on this channel that We've engaged with these comrades, and in a cordial discussion, they knew exactly what was coming. So for them to have reacted the way that they did was totally out of tune with the principles and the disciplines of the party.
So the court would have dismissed the application for an interdict to prohibit them from being, of course, replaced. But the review application still is going to go ahead. Do you see any chance of them succeeding there?
The review application? Well,
yeah.
I mean,
on their constitutional ground, they're saying that just administrative action was not given to them.
Look, from the onset, this was just dead in the water. We are focusing on our role as the official opposition. This is just a sideshow of individuals who were very opportunistic, clearly, because they were not in the party for purposes of advancing the agenda of, doing what we need to do, which is to emancipate our people. This is a selfless role. You can't, when you're deployed as a volunteer, now all of a sudden, and you're put there as a deployee, now think you're an employee. No one's an employee. So for them to have this sense of entitlement, thinking that they are special, more special than thou, that doesn't work this way in our party. That's not how we work here. They can go and do whatever it is that they want to do, but the fact of the matter here is the following. They're expelled. On whose ticket would they be going to the National Assembly in any case, even if they were to go to court? Who? UMkhonto weSizwe? Never.